Hello. Today I'm going to talk to you very briefly about the divorce and dissolution process in England and Wales. This is the legal process for terminating either your marriage or civil partnership. In order to be able to start this process, you need to have been in a marriage or civil partnership for at least 1 year before starting the application. I'm going to talk to you about the current process, but also the changes that are afoot which are expected to be implemented next year. So the current approach is that you need to be able to illustrate that your marriage or civil partnership has broken down based on one ground, which is irretrievable breakdown. This then needs to be established by proving one of 5 facts if you're divorcing, or one of 4 if you're going through a dissolution. These facts are unreasonable behaviour, adultery, which has to be admitted by your spouse on the response form I just described, and this is the one fact you can't rely on if you're going through a civil partnership breakdown. The third is 2 years separation with consent, the fourth 5 years separation without, or finally desertion. You can start this process online using an online application, using a solicitor or without, or you can do so on paper. You'll need to have your marriage certificate to hand, including the original document, as well as any translation if you married abroad. If you are the one starting the application, you will be called the petitioner and your partner will be the respondent. Once you've inputted all the details, either on the paper or online application, and the court has processed your court fee, the court fee is currently £550 unless you're exempt. They'll then issue the application. This means that they'll give it a case number and it will be in the court system. You'll then both receive an issued set of documents and your partner will need to respond. This is on a short form called an Acknowledgement of Service form, upon which they can confirm whether they've received the papers, whether they intend to defend the application, and whether they agree with any other claims in relation to costs or where you should be getting divorced. Assuming they respond quickly to this form confirming that they're happy for it to proceed, then hopefully the rest of the divorce or dissolution will proceed fairly smoothly. Once you've been notified that they've responded to this form, you'll then be able to apply for the first of 2 certificates. If you're divorcing, this is currently called a decree nisi. The decree nisi, or the first certificate, is an important stage to reach because it does mean that once you file any agreement about your finances, the judge is then able to consider it. Up until this point, you're not able to do so. Any agreement that you do reach about your finances isn't legally binding until it's been approved by the judge. And so getting to the first stage, the decree nisi or the conditional order, is really important so that you can then file any agreement that you do reach so that you can ensure it's later legally binding. If you're applying online for the divorce or the dissolution, or you've researched yourself, you may be aware that you can then apply for decree absolute, which is can take place 6 weeks after decree nisi. We would suggest you just pause before you do that, and we usually encourage clients to hold off on applying for decree absolute until the financial agreement has been reached and has been approved by the judge. You would go one step further than that if there is pension sharing, so if you're sharing pensions between you and your partner, because we would then suggest waiting at least 28 days after the order has been approved by the judge before you actually go on and apply for that final certificate. So whilst you might be prompted along the way about when you can take these steps, do pause before doing so. So that's an overview of the current process and what you need to be able to establish. Now, as I mentioned, there are changes afoot which are well awaited with an attempt to sort of end the blame game and reliance on fault that there is now. So the Divorce, Dissolution and Civil Partnership Act received royal assent, and this is basically designed to a new law which will allow a spouse or a couple to apply by making a statement of irretrievable breakdown rather than alleging facts about conduct. Now, this is well awaited because there is currently an unsatisfactory position if a couple simply want to separate and there is a breakdown of their marriage or civil partnership and there isn't necessarily any underlying reason for that. So this is well awaited and we're expecting it to be implemented next year. So as I said, that will enable a spouse or couple to apply by making this statement. There'll be a new minimum time frame of 6 months, which will be created to give effectively a cooling off period and give couples time to reflect, turn back if they wish to do so, or to proceed thereafter if not. The judge must take this statement of breakdown as conducive, and so it will move the ability to defend the divorce, which is something which is currently quite problematic. So this is going to be a shift in the process, and we'll also see the removal of the phrases I mentioned, such as decree nisi and decree absolute, to be replaced with conditional order and final order, which will be more palatable to understand. One other thing to bear in mind is in relation to the timing of your divorce or dissolution petition. Generally speaking, assets in England and Wales can be transferred between you and your spouse without any no gain, which means that there shouldn't be any capital gains tax on any particular assets which are transferred between you during the tax year of separation. So it is important just to think about the timing of your application for divorce or dissolution, and just making sure you take some tax advice from your advisor about whether making this application now will have any impact, because it is something that some people aren't aware of, and it can then potentially give you a short window to then potentially negotiate. So do think about the timing. The only other thing to think about around filing for divorce is considering whether or not you have the ability to file for divorce in any other country outside of England and Wales. So for example, if you were born in another country, have lived there recently as a couple, your spouse is based in another country, or you've got assets there, do think about taking some advice both here in England and Wales and also in the other country, just to make sure that you're actually filing for divorce in the right place, which is going to protect your best interests. The law in relation to the division of assets in England and Wales is quite discretionary, and there are different approaches in other countries, and so it is important just to take stock before you do file for divorce in a particular country about where is best for you to do that. The key with that is just making sure that you act quickly and take the advice promptly, because the timing of the petition can be essential. So I hope that gives you a useful overview of the current divorce process and dissolution process, as well as the changes that are afoot. If you're thinking about going through a divorce process at the moment, and you don't have any particular reasons for rushing things through, and you don't have the basis for doing so because you and your spouse have simply decided you want to part ways, then there is an opportunity on the horizon for you to then be able to file for divorce on the basis that there is this breakdown without having to wait the 2 years.